Hello, everyone, and welcome to another episode of the TCLF One-on-One series. Through the One-on-One series, we aim to interact with the best legal professionals from India and around the world. Today, we seek to have an engaging conversation about the Insolvency and Bankruptcy Code, its past, its present, its future, and we're very happy to share that we have one of the leading names in the policy field with respect to that particular area of law. We're honored to have Mr. Akash Jauhari with us today. Akash is currently a co-lead at the 𝐓𝐶𝐋 Center for Legal Policy. He's currently working with the Corporate Law and Financial Regulations Group there. As a part of his work profile, he's working on some of the leading policy projects with respect to insolvency and bankruptcy code, as well as the regulation of financial professionals. Before working at 𝐓𝐶𝐋, Akash has also worked as a practicing advocate at the Vadhva Law Chambers. And during this entire stint, he has managed to serve as a specialist editor on one of the leading commentaries on the insolvency and bankruptcy code. Very happy to have you with us, Akash.
Thank you so much, Asha. Thank you so much for inviting for this.
Yeah, I'm absolutely looking forward to this conversation. Now, Akash, I just want to talk about your journey a bit because it seems to be a very interesting journey. You were a practicing advocate and then you shifted on to the policy, to a policy think tank. So, what was the motivation behind this shift? And how did you adjust to the change? Because the lives are very different. Because on one hand, you are dealing with the practical areas and the practical, facets of law, and then you shift to, let's say, more of an academic role.
Right.
So, how was the shift and how did you adapt to it?
Yeah. So, of course, I'll not say a shift, but a very holistic shift with respect to my career. Essentially, when I started practicing, something that was also implemented around that time was Insolvency and Bankruptcy Code. And I saw the implementation of this law from the very nation stage, like at the time where everyone was just figuring it out, like what will be the implication of this law. And at my earlier office as Vadhva Law Chambers with Anirudh sir, I got an opportunity to also explore this from rather than only from a practice point of view, but also from an academic orientation. We did some books and all. So my shift to 𝐓𝐶𝐋 essentially was driven by my interest in insolvency and bankruptcy. They were looking for people to essentially work in this area. And once I joined 𝐓𝐶𝐋, I actually find it really interesting because it just changed your horizon the way we used to look at when we used to practice. So as you are aware, so when we practice, essentially we look at from a very, very narrow perspective from what exactly is something that will be beneficial to a client, then shifting it to more of a broader policy perspective, that what is something which is the like the economic logic that the law is trying to achieve. So that is something that actually something that stuck with me, and I actually liked working at 𝐓𝐶𝐋. So right now, I'm rather than working on insolvency law, also exploring the functioning of financial sector regulators. That's the area which I specialize in at 𝐓𝐶𝐋 Center for Legal Policy. But that was exactly my shift. But now I'm finding it really comforting because 𝐓𝐶𝐋 is kind of a unique organization when it comes to legal policy, because a lot of time when you talk about policy, it's essentially something which is within the domain of economists. So lawyers playing a role in policy was something, as an idea, was very enticing for me. So that was one of the major reasons why I shifted to 𝐓𝐶𝐋. Yeah.
Right. And Akash, as you've rightly mentioned that when you were a practicing advocate as well, you had written a number of, articles. In fact, you were working on a book, as you've stated, and you had written a number of callings, and you still do. So, what are your thoughts on this entire process? How important is it for practicing advocates to, remain engaged with academic endeavors? Of course, it's very important from the visibility point of view. People recognize you and, it's important. But, from a more, specified perspective, how important is it to remain engaged in those academic endeavors?
Yeah, that's actually a very interesting question because as practicing lawyers, we tend to see law from one perspective. We essentially we generally have a question of law that we want to answer, a question of fact. We essentially take a deep dive on that. So the point where academic endeavor, of course, apart from the marketing aspect of it, you essentially go and people, of course, recognize you from your writings. The other idea is that it gives you a more holistic idea of how the law is actually proceeding. And in fact, in most of the litigation that you have seen in past also, especially the evolution of jurisprudence, it has been lawyers like us who have been pushing the boundaries of the law from one side. And then after a heavy set of litigation, court essentially end up settling that what is the right approach. So I particularly feel that it is important that there should be a balance of both the things. Definitely lawyers needs to push the boundaries of law to actually pull out the right interpretation, right questions. But the place where academic writings actually helped me particularly was trying to see law from a more realistic perspective, something that is trying to be achieved. Like, for example, even when you talk about like the arbitration policy, when you talk about insolvency policy, as lawyers, like whenever we are challenging an award, generally we talk about a pro arbitration approach. But generally, whenever we are essentially challenging an award, we go into the merits of each and everything, even when a award has already been decided. So of course that is your job as a lawyer. But when you're writing academic stuff, when you are seeing policy and seeing this question from a holistic perspective, it's actually makes you also realize that how far you can actually push the boundaries of law, so that you can also advise your client on a rightful basis, rather than giving them a hypothetical understanding that okay, fine, anything what you want would be done. So I think that's where the academic writing actually helps. But it's also the other way around, to be very frank, because when you are actually practically experiencing implementation of the law, so drafting a law and implementing a law are two different things altogether. It is only when law essentially sees its merger from the reality, then the lawyers also have an important duty to play, because they also understand that what are the issues in any kind of implementation. So when they do an academic writing, it becomes, for example, right now when I am not practicing, when I keep on reading articles from a lawyer's perspective, it gives me an idea to understand that what are the fallacies that needs to be addressed, where are the bottlenecks that is coming, because lawyers are like the people who are seeing it on the first hand, that what exactly are the issues with the law and how to resolve it. So their perspective becomes very interesting, especially when they contribute to academic writings.
That's a really, interesting way to put it. And, from my limited experience as well, what I can say is that the matters that stick with you, the
Hmm.
matters that you remember are usually the ones which, involve a very, dynamic and an unexplored area or question of law. Something more, other than, just the merits or the facts of the case. Of course, they matter and they matter the most when you're, explaining it to the court. But what sticks to you is that I had researched on this question of law and, I got it settled and, I got to know about this. So I think that's very important. And that comes from an academic drive as well.
Yeah.
So I absolutely agree with that. Now, to a very, to take you to your past, to say, so to speak, when you were working at Vadwan Law Chambers in your practice days, uh, can you remember or recall a dispute that you had worked on the Insolvency and Bankruptcy Code, for example, that that has managed to stick with you, and you want to share that experience with us?
Uh, so one of the cases which I remember, it, of course, not a very heavy big litigation, but it actually had a very big impact. It was a it was a matter that we were doing before the Allahabad High Court, I remember, and it was something pertaining to whether the moratorium which will extend to a guarantor. So of course it was like a huge set of litigation. The matter got actually settled, but it was one of the initial orders that we got, wherein the court essentially held that the moratorium will extend to the guarantor, something which is seen antithetical to the approach of IBC right now. But the reason why I pointed out that case essentially was that, like when I look back to the case, essentially it was a new policy that is, and again coming back to the point where we're saying with respect to academic writing, it was a new policy that was getting implemented. Each and everyone, like all the people in the courts, were still figuring it out, that what exactly is the right approach. Rather than seeing the policy from a more holistic perspective, we were seeing it particularly only on the point whether the moratorium, which is the section 14, should be implemented. And in fact, I think a lot of litigation around that time was only sticking around section 14 because it was one of the first time the matter got implemented. So probably none of the lawyers at that point of time, or the matters that was going on, was seeing it from the aspect of completion of the proceeding, which is like once the resolution plan is actually approved. So it's a very interesting matter that we did, wherein we were trying to understand that what do you mean by a debt? Like when you talk about a guarantee, if suppose I and you enter into a relationship and there's a third party and we have a guarantee relationship, how does a debt actually function? Whether it is a debt, like both of us will have a joint receivable liability, and when the law intervenes and says that there'll be a moratorium on one aspect, how does the equities flow with the guarantor? So apart from a more practical approach that we have right now, a lot of discussions in that case at that point of time was also from the perspective that what will happen to the guarantors if the moratoriums are not actually extended. So it's a very interesting case that I always keep with myself, because it actually shows you why at the very start of a policy when it is getting implemented, why it is so much important for us to, or from any policymaker to start conveying the basic ideas that is important. Like for example, the BLRC report. Had insolvency law been implemented, BLRC report has been something that the committee work that actually happened has been continuously relied by the court to give it a right direction. So conveying a policy becomes as much as important as compared to like bringing out a law. That both the things have to go side by side. That's something I recollect from that case.
Yeah. I think I've heard about this case a lot. It was in the Allahabad High Court. I keep hearing about it. And in these kind of cases, I also have another dimension to you. What usually happens is that rather than judging whether the approach taken by the court at that point of time is right or wrong, of course, these are the merits of the case or the merits of the decision. You are fair to criticize, you are fair to, go by the court's decision. That is a whole different dream. But what I think lawyers usually miss out because they're so connected to the, interest of or protecting the interest of the client is that a judge has actually, taken the endeavor to decide that question of law, which is
Mhm.
a very big thing, in a country like India, and where these kind of laws, or let's say insolvency and bankruptcy code, or laws like arbitration, which keep on developing. There's a new development every single day, and in the midst of all this, when a judge goes ahead and decides a question law, that in itself says something about the courts, leaving aside the merits of the decision itself. So this is something, from a more practice oriented thing that I think the lawyer should also focus on.
Oh, no, absolutely. This is the point that we were discussing earlier, that it is up to the lawyers to push the boundaries of law. Had that
Right.
decision not been there, the entire
Yeah.
jurisprudence related to what is the role of guarantors in this entire insolvency bankruptcy process might not have actually started. Of course, it might have started at some point of time, but
Right.
going in one direction only makes you to realize that there's another way also. So I think from that
That's
perspective,
absolutely
yeah, it becomes very important to see case from an individual perspective, because as I was saying, that it's only when you try to highlight this the actual realities of the law, that what will happen if the fact that if the entire law has been, like for example, if the main creditor is getting a haircut or
right.
some benefit of the process, what will happen to the liabilities of the guarantors? So this is a very important question to answer, and of course either
Right.
ways how the judgment actually went, but it starts a debate and which ultimately culminates to something settling the law.
That's absolutely true. Now, Akash, moving on to the more specifics, of the working of the court. Recently, the government announced the appointment of some new members to the NCLTs, various NCLTs. And there have also been talks about, creating a common interface or a common software to link the various regulators in the field with the NCLT to, make it a more efficient process. So from my experience, and I'm sure from your experience, you must have also experienced that one of the biggest reasons behind the backlogs is, the way the NCLTs are functioning, not due to their own fault, but just the lack of members. And sometimes what is happening is that the members are to man two different benches on a single day. So bench two would be sitting in the morning, and the same bench is bench six in the afternoon. So things like that. So, what do you think about this move, about this whole appointment process? And, what are your general views on this?
Yeah, it's actually a very positive process. Like right now, the only answer to the backlog of cases is probably the appointment of NCLT judges, and I think that's the place where a lot of active intervention from policy and other perspective also is required, because we have a code in place. I think the bottlenecks over here is the execution, and as you have rightly said, that once the number of judges essentially are increased at NCLT, which is essentially strengthened from not just from that perspective, but also from the perspective of ensuring that it is well equipped with all of the facilities. It'll actually play a make role in reducing those bottlenecks that we have in implementation of the code. Because ultimately, NCLT, so something major that actually IBC as a policy did from the last regime was changing the intervention of state. So if you see the earlier policies which were there, which were essentially the SICA, Sikh Industrial Companies Act, and also the regime that was proposed by the Companies Act earlier. Something which was very common and dominant in that was the state intervention. When I say state intervention, it is essentially in the terms of who essentially decides whether the company is a Sikh company, who essentially decides that whether revival plan that has been finalized is the right plan, which essentially was ultimately this job was ultimately given to the BIFER and NCLTs earlier, which eventually, and the delay in those forums ultimately delayed the entire process. So something like benchmark, which actually happened with the development of IBC, was that the role played by the state was ultimately of a facilitator rather than someone who is actually actively deciding how to revive or decide the fate of the company, whether the viability is there. So from that perspective, NCLTs were given a role of supervision. So which was essentially now the major task is there with the COC and the creditors and the debtors to ultimately decide the fate of the company. But ultimately, it's NCLT who has to finalize the resolution plan. So it becomes very much important for, of course, strengthening the bench and also for NCLT members to understand that what is their role. And Supreme Court and other courts, especially NCLT orders also, which I'm seeing for some of the orders which I see, have been very cautious in not entering into the domain of viability and non-viability of a resolution plan, and rather than just appreciating the fact that the process has been followed and the basic ingredients are actually met. So you're right. Definitely, it's a like appointment of NCLT members is the right step in the right direction, and in fact, probably we'll need more number of judges at the NCLT level soon.
Yeah, I absolutely agree with that. Another, ream that has been a lot of, that has seen a lot of discussion in the recent past is the pre-packaged insolvency
Yeah.
process. It was launched with much fanfare in 2021, but as I was reading the recent statistics and the reports, there have not been much takers of this entire process. Now there are multiple reasons, and this is what I would request you to delve upon. First of all, what is the difference, in brief, what is the difference between pre-packaged insolvency resolution process and a normal CIRP process, corporate insolvency resolution process, and what are the reasons as to the lack of success, so to speak, behind this entire process as of now?
Yeah. So of course there are a lot of key differences. I think the primary thing which actually differentiate between pre-pack and CRP are two aspects. Firstly, of course, pre-pack has been confined to only MSMEs right now. It's only for small companies. And the second aspect is that it is actually a negotiation which is already finalized to some extent before the process starts. And the process is only reopened just to ensure that the due requirements are fulfilled, all the stakeholders' consent is required, and ultimately the approval happens. The stark difference, which also relates to the how the pre-pack regime is actually structured, is a debtor in possession model. Because ultimately, if you see MSME, unlike the normal CIRP process where there is a 29A bar for the promoters who are declared NPA to come back, in MSME there's an exception. So promoters have a better chance to probably get back the company, because especially for small companies it was something that like a lot of people have been writing and realized that it becomes so very, for example, if there's a big company then there'll be a lot of takers. When there is an MSME which is working in a very niche area, in order to revive that company the role of the promoters become a little bit more important. So that becomes a crux of why we came back with a DIP model under the IBC, the pre-pack regime, because ultimately I think again the stark difference between the earlier regimes and this IBC was the creditor in control model, because we were asking the companies or promoters to let go of their management and creditors to take over through IRPs, and then then both the creditors and debtors were in a balanced negotiation position. With pre-pack, of course, there are proper checks how the creditors essentially can or through IP make a check in the process, but ultimately the DIP model is which is very crucial or stark distinction between how the CRP is structured and how the pre-pack is structured. Now, in terms of the implementation of the policy of pre-pack, I think, of course, there are a lot of criticism and concerns people are raising. And of course, all those are valid concerns also with respect to implementation of pre-pack. But something which what I particularly understand and what have been my discussions with the stakeholders, lawyers, and others in practice, they have probably been two major bottlenecks. So one of the bottlenecks is that for a pre-pack to essentially succeed, it becomes very much important that in the informal stage, the financial creditors and the debtor come on board, take a haircut, because there's a base resolution plan which is required to be implemented at that stage. So they have to come up with a base resolution plan. It means that there have to be a haircut that has to happen before the process actually starts. And then ultimately the process will commence, the formal process will commence, the plan would be put for market testing, and ultimately the approval will happen. So that becomes a bottleneck because in CIRP, a lot of things happen kind of by compulsion because the process already started. So IM formation happens. So there's always a market testing that is a mandatory prerequisite of CIRP process. But for pre-pack, there is no market testing. So the valuation. So another special feature of the our IBC particularly is that rather than relying on speculations of what exactly is the value of a company, we essentially let the market decide. So when we go for an IM, we essentially let market come forward and say, okay, fine, this is the value that we are assigning. COC have a on ground real value with respect to the price of the company. But in pre-pack, the entire thing has to happen, especially at the informal stage, without any market intervention. So ultimately, it becomes difficult for financial creditors also to assess what is the right amount of haircut to give. So some of the bottleneck that was brought to my notice was also with respect to the fact that the initial negotiation becomes very difficult to take place. So because if the initial negotiation is there, then of course everyone is on board. It's very simple process. But the initial negotiation is something that becomes a problem. Another point is that is even because if you have to understand that this pre-pack policy is a policy that is there for MSMEs. MSMEs, and it was essentially came at the point where uh, we were just coming out of COVID pandemic. There was a expectation that there will be certain amount of stress that will be there in the MSME sector. But MSMEs generally have a lot of schemes and benefit that they keep on receiving. And MSME essentially, and that too corporate MSMEs. So the amount also becomes very less in terms of the takers of the process. So I feel that becomes like these two, three factors becomes the major factors why we are not seeing a lot of pre-packs. But in the last few years, of course, though there have been like one or two cases, so it will not be like the right. Even if I say that it's the right anecdote, it's not the right amount of anecdotal evidence also to say that it has been a successful or not. But something which is very interesting coming is that the places where the process has actually been completed, it has happened in a very short duration of time. So if we just see that one or two cases which has actually happened, the time that was taken, uh, I'm forgetting the name of that entire case, but the time that was taken was quite less as compared to generally what we see in CRP process. So that might be some of the positive takeaways from the process that we can see. Yeah.
Right. I think one of the reasons that I had read about, and I think, from a more practice oriented thing and speaking like with the officials from banks who are involved in this entire process, who are usually in the creditor position, is that their opinion is that since this is restricted to MSMEs, as you mentioned, the debt amount in itself is not very huge. Insofar, when you compare it to, let's say, the bigger corporates or non-MSME entities. And because of that, they feel that, for this amount of debt, we don't want to go through this entire process. Let us just get into an OTS, a one-time settlement scheme, and they want to get it done away with in that entire OTS process only. Instead of,
Right.
going to the NCLT, having a supervision on that front, and then engaging in this process, they straight away get into a dealing with the company. So that might be the reason, or one of the
Yeah.
other reasons. Yeah.
Yeah, definitely it can be a reason because see, one of the major requirement for when the process start is the cost associated with litigation and everything.
Right.
So if the banks are opting for it, definitely there might be some. So MSMEs generally don't have the wide set of exposure of creditors that a big corporation will have. So it
Yeah.
might be that one of the biggest creditor of MSME is just one bank who is open to an OTS, and then the MSME can survive. Because anyway, there are a lot of schemes which actually requires bank to also go forward and give some relaxations to MSME. So from that perspective, also you're right that it becomes a it's something which becomes a cost heavy thing for them,
Right.
and therefore a less taker. So probably had this process been open to like a broader sector, it would have been a different
Correct.
approach might have taken. Yeah.
Right. Now, and coming on to a question that has involved so much debate in the recent times, and we have also discussed it, outside this forum and when we met last, is about the whole liability of personal guarantors under the code. Now, recently the Supreme Court has come out with its judgment upholding the constitutionality of the provisions relating to the personal guarantors. There was a
Mhm.
constitutional challenge to this basis Article 14, 1921, all of that was there. Now, what are your thoughts on this judgment? That is my, major question. You can cover multiple aspects related to it. But one important aspect that, I would want you to touch upon, and this is, I'm just putting it from a very straightforward point of view and what I'm experiencing in the cases that we are dealing with in our chambers on the personal guarantor side, that from the 95 to 99 stage, I don't think that a proper appreciation, was done of the entire process. I think there should have been more, because what is happening is that even the jurisdictional facts are not being considered. So it's like an automatic machinery into place. And the personal guarantors are only coming in at the 100 stage. So to just, differentiate, facts or adjudicative facts can very well be left on to the 100 stage. There is no problem with that. But at least the jurisdictional facts, the very maintainability of the whole thing,
Mhm.
I think some kind of analysis could have be delved upon into that. And but the obvious flip side to that is, and the one way to argue it from the other side is, where do you draw the line for these jurisdictional facts? Because then everyone would say that mine is a jurisdictional fact. You adjudicated at the 95 or 96 stage. So, you know in this perspective, what are your thoughts on that decision?
Yeah, of course, the decision is definitely a positive step, and I think the major, to my recollection, I think the major arguments were basically a due process argument, the whether the principles of natural justice are actually followed. Of course, there was an Article 14 argument to it also, but a lot of arguments were with respect to how and what is the role of the RP in the admission process, and how essentially, sorry, how essentially the what is the role of a court in the entire adjudication process. And of course, right now, like after this decision, all the constitutional, I think the major constitutional issues, if I'm correct, are settled with respect to the IBC process. There's nothing which actually static. But of course, I take your point with respect to the jurisdictional aspect. The process, the commencement process starts at like two stages. One is the fact that uh, a person makes an application, then an RP is appointed, and then ultimately RP gives a report, and on the basis of that, the A essentially admits. So you are basically saying that at the point of appointment of the RP, there should be some consideration of the jurisdictional facts, right? This is what you're saying, right? Huh? No, no, of course. That's I think that's the point that court also considered. But see, delay becomes a very major aspect to the entire, and unlike the CIRP process, wherein when IBC came, it just settled the question of jurisdiction by saying that the registered office will ultimately be the jurisdiction. So there is no question altogether. It becomes a problem, of course, with respect to the individuals, because then in their cases, ultimately they can reside in different stages. So the entire jurisprudence of CPC with respect to residence, and whether it is the cause of action is arising in the jurisdiction of the DRT, ultimately will come into picture. But we'll also have to see that the law essentially assigned a very special role to the RP at this stage. And when I was going through the order also, I was seeing there was a lot of comparison that was happening between the RP, which is there in the part 3, for individual insolvency, and RP, which is there in the corporate insolvency resolution process generally. And like personally for me, I think the major difference is that RP has a little bit greater role when it comes to individual insolvency. Of course, the role is much more enhanced when you talk about corporate insolvency, when it is taking over the process. But ultimately, it will be very difficult to align both things together. So when an RP probably will function in a part 3, ultimately he's functioning kind of an independent body, because ultimately a regulated person. So he's giving its opinion. And something that I found very interesting in the Supreme Court's order was that Supreme Court gave very much reliance that the A has to apply its own independent judgment to it. And when you see in contrast with some of the orders of DRT or NCLT, which I think came, they have been relying a lot on RP's report and admitting the matters, which essentially is ensuring that the admission is little quicker as compared to this opinion. So it will be very interesting to see how this aspect of course, apart from all the other aspects of the opinion, which has said that, of course, due process norms are followed and everything. But this aspects of where they are trying to make a balance between the role of the adjudicating authority and the RP's report will be very crucial, because the way the narration of the judgment, the opinion actually is structured, it gives a lot of room for lawyers to essentially contest that the report of the RP is not the correct, fact, because RP's report ultimately can have that one balanced approach before the A. And A ideally should give a deference to RP's report before taking a conscious call, so just disregard it. So I think that becomes a very important point, because ultimately at that stage, all these jurisdictional issues can be adjusted. Because ultimately, the only drawback to that is the cost aspect. Because if suppose the ARP has prepared a report, and ultimately the question that on the point on which it is actually disregarded is the point of jurisdiction, so the entire process become redundant. But that report can always be utilized at the appropriate forum whenever it is actually going. So same RP can be pointed at that stage. When you do a cost benefit analysis, if the jurisdictional facts are considered at the very start, the reference point that the code wants the A to have, which is the RP's report, is not exactly there. So it will ultimately mean that the code has to go into the entire aspect of fact finding, whether the residence was right or not. And also you're talking about DRTs, which essentially are not exactly a summary code. DRTs are more and you must know it better. DRTs are more structured like a trial code. So for them to go into the entire question of whether the person residence, where is the person residence, it will take a lot of time. So if you see the spirit of the code, ultimately if the report comes to the A and A is relying on that, then ultimately A has something to rely on, then probably it will be better for them to give a judgment at the stage of section 100.
Essentially, two perspectives, came out in that judgment when an argument was being made with respect to the jurisdictional fact process, adjudicative fact process. Was that one, of course, the role of RPs,
Mhm.
how it is, how it is different in the personal guarantee, as you mentioned, in the personal guarantors process from the normal insolvency resolution process. Then what came on or what fell from the court was that, see that there's no case for you to make out that you do not have any opportunity. We will call on for a report from the RP, and at the section 100 stage we'll hear you, in a detailed manner with respect to that report. You want to contest that report, you want to support that report, you have an entire hearing process. So it's not like, you're leaving out on the principles of natural justice. It's just at the initial stage, to fast track the process, we have made it, we are upholding the constitutionality. Well, that was actually that, fell from the court. So yeah, from the cost point and, from the timeliness of the process, it makes sense. uh, yeah.
No, also because at the end of the day, see, generally what happens is on the way we perceive courts and tribunals in general, that bias, personally, I believe then something that it comes back to me also a lot of time, that whenever there's a question, it has to be decided at that point of time. You can't put it for a later point of time, because then the process cannot actually continue. But you also have to see that when you talk about adjudicating authority, when from an IBC perspective, apart from like being hard coded like courts and tribunals, they are also someone who is a facilitator of the process. So they have to ensure that the process continues, the delays are not happening, and then at the right point of time the right calls actually should be taken. So I think the major point is when the insolvency is supposed to start, that's the point where all the rights will get affected. So that should be probably the call where A should intervene and take these decisions.
Because the court said that, see, in fact, the interim moratorium is in your favor, is in the personal guarantor's favor. So there is no case to be made out for that.
No, no, actually, in fact, I find it very interesting why they were challenging. I don't know. I don't know the exact background of the matter, like the particular
Yeah.
facts. Find it very interesting. The personal guarantor is challenging the interim moratorium, that they
Yeah.
don't want the interim moratorium.
Yeah. Yeah. That is what the court essentially, came on to. Now, Akash, this has been a fantastic conversation, ranging on a lot of spheres of the insolvency and bankruptcy code. Now, my final question to you is, a lot of people want to go into the policy sphere, but they don't know where to start from, or, what are the things they should be doing to make a career in this. So, what are your, tips and suggestions to our viewers, mostly students or young practitioners who wish to develop on in this field? What is your advice to them? How should they, chart out a map for this?
So I don't have like a map plan or a chart plan for them, but something that drives from my experience is that, like, as lawyers who are actually practicing or dealing these issues on real hand, already like all the lawyers have like a greater role to play, and they can always like take up clues from their practice. They can do academic writings and other stuff. There are so many opportunities right now that are there in the market, because there are so many organizations like with you which are coming up. I think something which becomes very important when you are opting for a career in policy is something that actually interests you, because ultimately at the end of the day it is your interest that will drive. And the initial years, I think all the something that I try to do and still doing is I'm trying to explore different areas and try to find that what is something that actually excites me, and like probably a cause which I would like to really fight for. And once that is clear, then it becomes very, I think the next step is only just to put yourself out and like engage in more and more discussions, and however opportunity you get to actually explore that area. So that becomes very much important, because a lot of like juniors from my college keep on reaching out to me, and everyone I think have a similar question, because they are still at this fear of actually identifying what are the areas that they actually like. So it's always good, because right now, especially in a city like Delhi, there's so many opportunity to engage with so many people at a policy level. So yeah.
Thank you so much, Akash. That was very, very helpful. And, on behalf of the entire team, I would like to, thank you once again for your interesting insights. It was a really engaging and, I learned a lot from this discussion. And I, hope we can collaborate in the future as well.
Definitely, Shashwat. Thank you so much. Thank you so much for inviting. I really enjoyed the discussion.